Every day in the USA, people find themselves in court.
Jordan Dillon.
Yes, sir.
The court will next take up State of Kansas versus Jordan Jeffrey Dean Dillon. It is case number 2023 CR 82. Amber Norris appears for the state of Kansas. James Watts is defense counsel. Mr. Dillon appears at a court security Zoom location at the Butler County Courthouse. Court notes that this defendant was originally sentenced back on June 23rd of 2023. At that time, on a flee elude level 9 felony charge, he received a 6-month DOC sentence, 12 months PRS with a 12-month reporting probation. Mr. Dillon has been back before this court on previous occasions. In 2024, and then again earlier in 2025, both times receiving essentially dip jail sanctions for noncompliance with the terms and conditions of his probation. Matter comes before the court at this time for the third time on review of his original sentence on a warrant to show cause filed by Mr. Ketley. The defendant is alleged that in April and May of 2025, he submitted urine samples positive for THC. Further, unsuccessful discharge from substance abuse treatment at higher ground due to lack of attendance is alleged back in May of 2025. Mr. Watts, what are your client's intentions regarding these allegations?
Your Honor, I spoke with my client regarding the allegations. He's first alleged that he submitted urine samples positive for THC in April and May of this year. He would stipulate that, in fact, that is the case. He further stipulate that he was unsuccessfully discharged from the substance abuse treatment program at higher ground in May of this year, would waive hearing on those matters. He would tell the court, it's my understanding, my client reports that he is currently have an evaluation set up for Tuesday to re-enter that higher ground program. But he would stipulate to the violations as alleged and waive hearing in the matter.
Very well. Mr. Dillon, your attorney has announced that you would now waive any due process hearing that you'd be entitled to, where the state would have the obligation of proving these allegations by a preponderance of the evidence. You would have the right to challenge the state's evidence, present your own evidence, have the assistance of counsel, confront the state's witnesses unless good cause was shown. And I need to point out to you that among other lesser remedies, such as the ones the court has used in the past, the court could consider just an outright revocation of your probation and having you serve the remaining balance of your sentence locked up. Do you understand these things?
Yes, Your Honor.
And do you waive a hearing in this case and stipulate and agree that you committed the violations as alleged in the warrant to show cause, which are submitting urine samples positive for THC and unsuccessful discharge from substance abuse treatment?
Yes, Your Honor.
Very well. Court finds that the defendant is knowingly and voluntarily waived a hearing in this case, stipulate and agrees that he committed the violations as alleged in the most recent warrant to show cause. These are substantial and material violations of the terms and conditions of the defendant's probation with community corrections. We'll now turn to disposition. The court will take recommendations in this case. Ms. Norris, on behalf of your office, what recommendations are made?
Thank you, Your Honor. This is defendant's third warrant to show cause in this case. He's previously been before the court. He was before the court in March, where the court gave him 2 days in jail and an extension. Before that, he had 3 days on a probation violation back in June of 24. And then he's also had 2 and 3 days from his ISO for voluntary sanctions with his community corrections officer. Your Honor, his problems seem to be the same. He's having dirty UAs, and he's not engaging in and or completing substance abuse treatment. Those are consistent issues that the defendant has been having throughout his probation. I think, basically in all three warrants to show cause, these are the same issues, still using, still having dirty UAs, and still not going to and or completing treatment. Same with his previous sanctions that he did voluntarily with Mr. Catley. Those have to do with his substance abuse treatment, either not re-engaging or being unsuccessfully discharged from the program. Your Honor, it appears that he's just not getting it at this juncture. We are basically about 2 years in on probation, and defendant still is not quit using, and has not completed treatment as the court ordered as a condition of the probation, basically from the very beginning. Your Honor, we're just over 2 years from the date of original sentencing, which was June 23rd of 2023. The defendant was ordered to 6 months DOC. And Your Honor, at this juncture, based on the same behaviors being repeated over and over again since going on probation in June of 2023, state would request that the court revoke the defendant's probation, that he be remanded to serve the balance of his underlying sentence. He has 27 days of jail time credit from basically all the sanctions that he has served, whether they be the voluntary ones with Mr. Catley or the ones that the court has ordered as sanctions for his previous probation violations. I would ask the court address additional court-appointed attorney's fees and the bid's application fee. And I do believe that any and all fees still due and owing would need to be forwarded to collections.
Very well, Ms. Norris. Mr. Kentley, as the ISO assigned in this case, do you have recommendations to the court independent of Ms. Norris or in addition to Ms. Norris?
I don't, Your Honor.
All right. Mr. Watts, I'll turn to you. As defense counsel, what recommendation do you make regarding an appropriate disposition here?
Well, Judge, I'd love to tell you that I have something different, specifically different from the state in terms of why we're here. Mr. Dillon seems to maybe making the same mistakes over and over again. And at this point, he has gotten a couple of relatively brief sanctions in the county jail. I would argue, Judge, it's time for a county jail sanction, but a significantly more severe one, starting with a minimum of 30 days and perhaps up to 60 days in the county jail. My clients tell me county jail time is much more significant than Department of Corrections time. They'd rather serve it DOC or serve it in DOC than county jail. I would hate to, however, to simply throw our options away with this young man. He's still relatively young. So, Judge, we'd recommend a 30 to 60-day sanction in the county jail.
Understand your recommendation, Mr. Watts. Court at this time will address Jordan, Jeffrey, Dean, Dillon at this time, and I'll ask the defendant personally. Mr. Dillon, do you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present here?
I know I've messed up and whatnot, but I have my son that was just born on the 25th, and I've been making sure ever since I got out last to just stay out the way and not do anything. I know it's too late, but I'm sorry about that, and I accept whatever you all decide.
Mr. Dillon, what I don't understand is here you are on felony probation and you continue to mess around with an illegal substance called marijuana. Why take the risk, especially when you are a recent father? Why would you mess around with a street drug like that? I just don't understand.
Honestly, I don't know. I was just raised around it, but I ever since I got out last, I have not been using. I've been, just staying clean and whatnot. I've been trying to do right.
We just got out last, apparently, about June 16th. At least that's when you made your appearance before the judge on this warrant. And you apparently bonded out soon thereafter. I note that the bond that I see in the file from earlier this year was with second chance bail bonds. Of course, that was actually your third chance. Mr. Dillon, the court also notes that the crime of conviction in this case is not necessarily just a drug possession crime. It was a flee and elude law enforcement, which this court generally considers to be a very serious offense because of the potential that while you're eluding law enforcement, somebody else gets hurt that's innocent because you take elusive steps instead of submitting to law enforcement in the first place, which is not only dangerous for the officers involved, it's dangerous for you or any passengers in your car or innocent bystanders or other people on the roadway. So it's a serious crime to the point where the legislature has made it a person felony. So they consider it obviously a very serious crime. Now, you received a relatively light sentence to start with. It was this court's goal, Mr. Dillon, that you successfully complete probation. And I have no doubt that it was Mr. Ketley's goal that over the past couple of years to try to turn you into a successful completion of community corrections assignment. But you refused to let yourself be successful. There were a couple of things that you were required to do. Stay away from drugs, which, at least to the court, seems relatively straightforward and easy to follow. And number two, because you have some underlying issues regarding decision making, to get through and successfully complete a substance abuse treatment program. You didn't do that either. And that was, to a certain extent, a focal point of your probation. So if you're not going to stop using drugs and you're not going to go to treatment to try to change your behaviors, the only thing left for this court to do is to enter an order, and the court does enter an order, finding that Mr. Dillon has not successfully completed probation, that his probation has failed, that this is essentially the fourth time Mr. Dillon's been before the court to address this case, the original probation. Twice before we were here on revocation. Apparently, Mr. Dillon, nothing I said or nothing this court did on those prior revocations made one bit of difference to you. And I have no reason to believe that if I were to enter probation orders again today, even after a sanction period is served, that that's going to have any impression on you either, quite frankly. You just don't want to make all the changes necessary to be successful on probation. And what you've done over the last few weeks does not convince this court that you would be a candidate for long-term success. So regrettably, this court will enter an order at this time outright revoking the probation of Jordan Jeffrey Dean Dillon, ordering him to serve the remaining balance of his prison sentence in Department of Corrections custody. Because of this order, the court will waive any additional business assessments. Any unpaid amounts in this case will be referred to collections, if there are any. I will announce in this case that the original sentence, of course, was 6 months. And I'm going to presuppose that the post-release supervision period was ordered at 12 months.
I think that's correct, Your Honor.
It is.
Yes, it is.
Mr. Dillon, a couple of recommendations from the court while you're in Department of Corrections custody, and you won't be there very long. Earn every good time credit day you can so that you can get out as soon as possible. And while you're earning those good time credits, if they have any type of rehabilitative program that you might benefit from in Department of Corrections custody, that you take advantage of that program so that you can be 100% successful when you get out in just a few months. The sentencing journal entry from today needs to reflect the accrued jail time credit. Ms. Norris, I have little doubt that your computation that you gave the court today is a correct one. Apparently 27 prior days. And I'll just make the observation that that obviously constitutes a great number of different jail stints, Mr. Dillon. I don't know how 27 days got accrued 1, 2, and 3 days at a time. But obviously you've had a number of jail stints and they just haven't worked to correct your behavior. And I think it reinforces and backs the court decision that jail sanctions are not going to be effective in helping you complete probation or the sentence in this case. So I'm going to order Mr. Dillon into immediate custody of the representatives of the Butler County Sheriff's Office until his custody can be transferred to the Department of Corrections to serve the remaining balance of the 6-month prison sentence originally ordered and reaffirmed by the court today. Anything else we need to address here, Ms. Norris?
No, Your Honor, thank you.
Mr. Watts?
No, sir.
Very well. If there's nothing further, the Dillon matter is in recess.